No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report programme. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that legal question that doesn't quite fit into the other topics we discuss here on the Law Report. So we'll be taking questions on anything to do with the law, but we won't be taking questions on labour law or property law. So those are coming up in the next couple of weeks. So if you have any questions on those topics, just hang on to them. And when the time is right, we'll get round to those. But just before we begin, a reminder that there's a list of available documents on the Facebook page, Law on SAFM. If you'd like any of them, post a message on Facebook. But please remember to include your email address, or if you don't have access to Facebook, you can email me on law@safm.co.za and I can send you a copy of the list and then you can choose what you'd like. Well, I'm joined once again this evening by attorney Nicoline Skuman-Loan. She's a director of Skuman Law Inc., Attorneys, Conveyancers and Notaries Public. Nicoline, good evening. Welcome back to the show.
Hi, thank you for having me as always.
And if you have any questions for us, you can call us on 0892 10 2010, 0892 10 2010. And we do have a few emails to get through, but you can call in the meantime. Just leave your name and number with my producer and we'll call you back as soon as we're done with the emails. Right, Nicoline, we have a few emails to get through tonight. The first one is from somebody, from Len, who actually contacted my predecessor, John Orr, who some of you might remember did the Law Report before he retired and I took over from him. And he says here that he got some advice on a deceased estate in which he had a claim. He said he was given sound advice. He pursued the claim via a legal firm and it's now gone on for years. And when the estate was advertised, he contacted the master's office with the objection to the final liquidation and distribution of the estate. This was done by his attorneys on the 29th of June 2011. There was a follow-up correspondence in August of 2012 and nothing has happened. And we, according to him, have now appointed a firm of accountants to proceed with the matter. In June 2014, we sent another letter to the master's office detailing our position. Again, no progress. My question is, what now? Is there a person or office I can contact to try and obtain some reaction from the master's office?
You see, this is really a sticky situation when you involve the master's office on this level.
But why would it go on so long?
I'm speaking from personal experience. We're also dealing with more than one matter at the moment wherein we've raised an objection to the liquidation and distribution account. And theoretically at that point, there should be an investigation and to see essentially where's the money gone, because an objection is only raised if there is some issue with the accounting. So we've done this to be exact, in November, December last year, and in some of the other matters earlier, and neither of those have had any progress further to that because the master has to do this investigation and give both sides to this account that has been filed equal opportunity to voice their concerns. And if one side, particularly let's call it the not necessarily guilty side, but the side where one can raise a bit of an eyebrow, if you've got them not wanting to cooperate, it does drag the matter out. So in a nutshell, the only recourse you have if it drags on with this back and fro, your only option is really to launch court proceedings.
But he says now they've appointed a firm of accountants. Will that help?
Yes, it may help from an accounting perspective. With most of these, it depends, of course, on the nature of the objection, but most of these objections always involve some form of fraud. So, well, in my experience anyway, not necessarily always, but it is very useful to have accountants involved because they know what to look for and what to identify from an accounting perspective, which not all firms of attorneys, with all due respect, are capable of doing. So we also work quite closely with forensic accountants when we deal with these type of matters, and that would help from understanding where the money could have gone. But if the master doesn't relieve the executor, for example, of his or her office and replaces them with someone who can do a proper liquidation and distribution account, find out where the money's gone, retrieve it,
if they can,
and then pay the heirs, that's really where the bottleneck is created. So in my view, it would be best to get someone to launch court proceedings.
Because he asks, is there a person or office I can contact to try to obtain some reaction from the Master's office?
You, at most, I don't know which Master's office this is, presumably Cape Town, but, there's no indication. I'm just assuming. Then it would be to physically go to the Master's office to try and make an appointment with the Master himself of the particular Master's office and to have a discussion. Unfortunately, because they've got these internal processes which they have to follow once an objection gets raised. And these internal processes are very much of not really choosing sides up to getting to a certain point where court intervention is really the only way to push the Master and all the parties concerned into that particular direction.
We're looking at 4 years already, though.
Exactly.
So is that not unusual in a case like this?
No, not with these cases, it seems.
Oh, really?
No, I'm sad to say. It's and particularly when, we don't know what is involved in the objection in this case, if it's maybe just a slight error or if it's really some deep-seating fraud. If there's allegations of deep-seating fraud, then one needs to trace the money and where it's gone and where it could have gone if you're talking about misappropriation and all these really serious offenses. And that you need to really turn quite a few stones. So long story short, I would strongly recommend that this listener gets in touch with a firm of attorneys that could take him to litigating this matter. And it needs to be someone that knows how the process works and what portions of the internal processes within the Master's office have already been exhausted. Otherwise, that will further delay the matter.
Right, Len, it sounds like you still have quite a long road to travel, so let's wish you luck on that one. Then have an email from Harvey who says, I'd like to know what difference a will would make where an estate is straightforward. There are 4 dependents with equal shares and all have agreed with this. There's no complications and one of them has been appointed executor.
Well, you know how it goes with these topics and me. I've always maintained, in my humble opinion, that a will shouldn't be, you shouldn't decide to get yourself a professionally drafted will on the basis of how many heirs you may leave behind or descendants you may have or dependents. Or how much worldly possessions you have. Rather, in my view, it's very much dictated by the amount of debt that you have. So someone as young as, for example, a student with a student loan should, in my view, have a will so that it could dictate what would be done with the debt. And if we take the example of the student, surely that is someone whose parents or siblings would benefit from a relatively small and estate that they would leave behind, but at least it would deal with that debt in a more efficient way than leaving a situation where no one would know. So what are we going to do about this, and who's going to pay, and what are the terms? So, in my view, it's always been that there are certain trigger events in life that compel you to have a will. Debt being one of them, and debt we can incur as early as being students, by example. And also then, of course, getting married, having children, adopting children, and then any big financial transaction, really, including owning a business. So it's more about life events than it is about how many people are to benefit and or how many possessions are to be dished out or divided between them.
Now, what happens is these 4 dependents with an equal share, they've all agreed that they're going to get that. There are apparently no complications. One of them has been appointed the executor. But what happens if the person whose will we're talking about dies, and they're now dying intestate, which means they're dying without a will? Doesn't that delay everything?
It really depends who these people are. Okay, 4 dependents, we presume, are children. But a dependent, in terms of legal interpretation, can also be an elderly parent who lives with you and they are financially dependent on you, or a sibling, or someone with disabilities, and so on and so on. So it's not necessarily a child. We've come to understand it to mean that in normal layman's terms, but it's not necessary from a legal perspective. So firstly, we need to see, are these people really the children? And if so, are they blood related? Because if they are not blood related and this person were to die without leaving a will, and let's say there's a spouse also, then the estate would essentially be divided between the spouse and the children in a certain proportion. If there are only children, and remember this needs to be blood related or adopted children, then it would devolve upon them and it would go down the family line that way. Similarly, if there are no children, then it goes sidewards, in other words, siblings, or upwards, so parents, grandparents, their siblings. So it goes down the family line.
It's
just safer. And further, if I can maybe just add this, you have more control about who gets what, in what proportion, and you streamline the process. If you do not do this, and particularly in larger families, the children of one or more marriages or relationships are not always aware of one another's existence. So when someone passes, then you've got 8 people instead of the 4 to share with, and this four didn't know about the other 4, and so on and so forth. So it's really about who is to inherit, streamline the process, make it practical, make it quick and easy.
When is Wills
and
Week?
Cheap.
When is Wills? I mean, I'm just thinking maybe they're worrying about the fact that it might cost them money. Next month there's Wills Week,
yes.
So we can do it. If it is as simple as you say it is, you can have it done free of charge during Wills Week.
Yes.
So,
provided that all your dependents are of age, in other words, over the age of 18, so you don't have to set up trusts and complicated structures. Then the Wills Week is ideal.
It's a basic will. So, Harvey, I would suggest you think about the will. Don't leave it because it could cause complications later down the line.
And it costs much more to administer an intestate estate than it does one with a will. So it's overall, it just makes things a lot easier. And even if you do pay for your will, it's money well spent.
And it's better for my nerves.
Wills Week is between the 14th and the 18th. Of September this year.
Okay,
yes.
Great. Right, next email is from Tom in Velcom. He says, I'm asking this on behalf of my sister. She bought her second-hand car after the first one was written off. The insurance paid only the value of the car and she was left with a shortfall of 15,000 Rand. The dealer offered to pay that shortfall and that amount will be included in the debt of the new car. Out of desperation, she accepted the offer without taking time to think about it. A year down the line, she realized that she's going nowhere. It's like she's not paying anything. We don't know how much about the deal because she's still without a contract form. The dealer has given her the runaround when she requested it. The only thing she has is the offer to purchase form. And he talks about the car and the model, and the vehicle price was 178,246 Rand. The total cost, including VAT, is 241. Gosh, it's a lot more. 779 Rand and 21 cents. Her monthly installment is 4,926 Rand and 5 cents for 73 months. The total settlement after 70, so it's obviously a balloon payment. The total settlement after 73 months is 359,601. It's just... Is this market related? Please help us understand this. So first of all, she's obviously got one of those things with a balloon payment. So you're paying yourself stupid for 73 months and you still end up paying double what the car was worth at the end of it. And you have to pay that all in one lump sum at the end of the day. Am I correct?
That's how I understand it. I must admit, I'm not too well informed when it comes to these balloon payments and these different types of installment and hire purchase payments and so forth. But from a National Credit Act perspective or a credit perspective, this is most definitely up for analysis, and I would recommend that firstly one establishes whether the dealership is registered with the NCR or the National Credit Regulator. If they are, they should have done an affordability assessment on the debtor. In other words, to check that she can afford this. And they would have had to fill in quite a lot of paperwork to ensure that this is affordable and it's in her best interests and so on and so forth. So there's that credit assessment element of it. And then, of course, there are the rules regarding the administrative charges and the interests and so on. And what the National Credit Act prescribes as what we call in law the umduplum rule, which means that once the interest has reached the amount of the capital, it stops running.
Because, I mean, the car can't cost, with VAT and everything else, 241,779. And then at the end of the 73 months, she owes more than the car was worth in the first place. That's not possible, surely.
Exactly, which is what I'm trying to explain with the interest running
yes.
to the capital. So there is legislative regulation when it comes to how much interests and all these hidden costs, if we want to call them that they are allowed to charge. So I would strongly recommend that she seeks legal advice, that her attorney then requests this contract from the
Which
dealership.
she still can't seem to get.
I am quite convinced that these guys are probably not registered credit providers, and if that is the case, then it's a fairly simple process of having this declared reckless credit, and for her actually not to be liable for these amounts in terms of
because those figures don't seem to make sense at all.
Exactly. So it's very custom oriented. It's supposed to be a piece of legislation that works in conjunction with the Consumer Protection Act. So really get someone who can do the number crunching, who can check their registration with the National Credit Regulator, and then to make the court application for reckless credit.
But Tom, do that as soon as possible. Don't leave it any longer. Just rather get it sorted out now. Right. Danny says he was looking for documentation. He wants to know what a person needs. For example, when somebody dies, the people that are left behind, you need to have. He actually emailed me and wanted documentation for when somebody dies. So I sent him how to, do whatever you need to do. But he says, no, what do you need to do if you're still the living relative or the living person left behind? What documentation? He said he thinks he needs about 40 items. I don't think you need 40 items.
I must be quite honest, I didn't quite understand what he was asking, but
I think you need to prove that you are the living relative or something. He says like ID document, the marriage certificate, if there is one, banking details. And he says he heard, but he's not sure how true it is. There are about 40 items that you need to have when someone passes away.
No. When you report the estate to the master's office, then you need a few key documents, one of which being the death certificate, obviously proving that the person is deceased, the ID of the deceased proving that it's been endorsed with the deceased seal across it, and then copies of IDs, and in some masters' offices, proofs of residence of both the deceased and all the heirs. And that's about it. So it's a fairly straightforward, set of documents that you have to prove, very similar to FICA, really. And when it comes to the payment being made from the estate to the heir, yes, then you have to prove the existence of your banking details as an anti-fraud measure. And any attorney would be handling the estate on the deceased's behalf as executor or executrix would, of course, then take a reasonable step to check and verify those banking details before making any payments. I mean, if I take it for ourselves, we verify quite a few types of payments in that way.
There wouldn't be 40 documents, though.
No. At most, it's synonymous to your FICA check standard. Unless, of course, there are special circumstances and the insurance company has their own, for example, with insurance policies that need to pay out, they've got their own set of forms and things. Of course, yes, if you are the surviving spouse, then yes, the marriage certificate, but fairly simple, a handful of documents. That's maybe why I was quite confused, thinking that 40 documents, how or where, and I immediately thought, okay, but when you are drafting your will and you're thinking of the people who are left behind, making a list maybe of, listen, my ID is there and my PIN number is over here, and that kind of important document list or important info list. He says
what I'm looking for is the documentation that's required to have by the people that are still alive when a person passes away.
Okay, no, then it's similar to a FICA kind of standard.
Okay, so it's quite simple. Right, Jody emails and says, I'm a paralegal and it's really difficult to find employment. I've tried many different attorneys and legal firms, but experience is always the problem. Can I maybe do anything on my own to earn an income, including advice, civil litigation, wills and estates, property law and conveyancing, business law, criminal law and procedure, and even tax income? Can he do all of that as a paralegal?
Well, personally, I would say no, on the basis that Similar distinction that you have with registered construction professionals, builders, versus unregistered professionals. And essentially, it's an insurance element to it. In other words, you're in good standing with your professional body. If something does go wrong, I don't think anyone willfully makes a mistake or has a lapse of judgment, which occasions, damages claims for poor advice or whatever the case may be. So, or poor workmanship or whatever the case may be. So in my view, I would always discourage any customer to support someone who doesn't belong to a professional body. And as an attorney, you need to have the minimum 4-year LLB degree or the equivalent of on NQF level. You need to do your articles for 2 years or a year, depending on how it's been structured with the law school. And you need to eventually become member of one of the law societies and pay your member fee. And this secures your Fidelity Fund certificate, which is that insurance portion that I was talking about. If something does go wrong, then the customer or the client is protected. So I would personally discourage any client to support someone who doesn't belong to a professional body.
And also for Jodie, it's a risk.
It's a risk for her also, because if something does go wrong, you don't have the Fidelity Fund certificate, which gives you that bit of insurance. Also, these paralegal qualifications are not as intense and in-depth as the LLB. So you simply, you're not in a position to necessarily give informed advice, really with no offense intended. So it would rather... And unfortunately, the paralegal profession isn't one that isn't even synonymous to what it is in the United States and so on. Where it's much more, I think, much more known and much more applied. Unfortunately, most of the paralegals are become members of support staff. So I would discourage her. And at this stage, you need an LLB plus your articles, etc., to do conveyancing, to do notarial work, for everything that she's listed there. So I personally wouldn't recommend it. It's way too much of a risk to both her and the potential customers.
Right, okay. Tokozo in KZN wants to know what else he can do with an LLB degree. He's still doing articles, but can't find a job.
Oh, goodness. I think times are tough for everyone out there at the moment, so it's very unfortunate. And a lot of people come out of university each year and get channeled into articles and the marketplace. So it is quite oversaturated, particularly in our profession. Well, I've heard of, and I've got many friends also, that elected not to practice law after doing their LLB and their articles, and they've gone into various corporate positions as legal advisors. Some of them have branched out and done a qualification in the financial services industry and ended up working in-house for insurance companies. Some are in-house legal advisors for accounting firms. The world is really oyster.
There's a lot to do. You don't have to practice purely as a lawyer.
Yeah, and you could even become a politician.
Okay. All right.
More than one of our previous presidents had a law degree.
I think Madiba had a law degree.
Yes, and he also had a law degree.
Yes,
so it's definitely it's something that could open many doors. And so look at maybe corporate. Compliance officers or in all shapes and sizes and industries, and there your legal background becomes very helpful. Some estate agencies are even employing in-house attorneys to look over the contracts and be in compliance in that perspective as well.
There are quite a lot of options. So just go out there and have a look. By the sounds of it, there's lots and lots of things you can do.
Legal advisor, I think, in
any industry,
in
basically.
the industry, yes.
Right, we've just got 2 more emails to go. So if you'd like to call through now and leave your name and number, we'll get back to you. 0892 10 2010. 0892 10 2010. These were emails that came in rather late. I did send the one. I'm not sure if you got it. It's from Kamal Singh. Says, can a registered credit provider lawfully access a consumer's credit bureau information when that consumer applies for credit but without the consent of that consumer? And he's given a whole long story, but that's basically the bottom line.
Well, I know many credit providers, including the banks and insurance companies, of course, do those credit checks, sometimes mostly with, and mostly without, some 50-50. I would say just check what you've signed with this provider. Sometimes it's really in the fine print to say that you consent to the credit information being accessed. So if you haven't given the information or the consent, then of course it can be questioned. But, credit information is to a certain degree part of public record anyway.
Well,
so,
the reason he's having a problem with this is because the particular bank, I'm not going to mention the name, he applied for additional credit, an additional credit card. This particular bank then went to a particular credit checking organization, and he's got a problem with that organization that they went and checked with, because apparently 2 years ago, maliciously and unlawfully, this credit union changed his personal information to married, which obviously wasn't. His address they changed to Hideout Avenue, and his occupation was delivery boy, none of which was true.
Oh my word.
And so now he sort of says he doesn't want anyone checking anything with them because they've got all the stuffs all wrong. And he said they didn't ask him, and they just went ahead and did it anyway. And, he says apparently the bank said it was required to access his credit bureau information. And this was according to the particular bank, it did not extend to obtaining my consent to do so. He went to another bank, which on its Facebook page, on inquiry from something said on the Facebook page of a different bank, that it first obtains a consumer's consent to access his or her credit bureau information. So some of them, so it's not a given that they have to ask you.
No, because it's a part of public record.
Okay.
I mean, anyone. And I can also say from personal experience, anyone can access anyone else's credit information. The minute we have mandate from a client to do so, we've done so on behalf of many clients. We phone one of the major credit bureaus and we obtain it on their behalf. Of course, we do get instruction and consent and mandate to do so. But it goes to prove, and we've never been asked to verify that. Anyone can really access those records, and particularly for the credit providers, that is a very useful pool of information from a risk assessment perspective and in the affordability assessment that the National Credit Act compels them to perform. So that is crucial information for them. So one needs to balance the two concepts of really how much of your privacy has been infringed upon, how much damage have you suffered by this, by not obtaining the consent, versus the credit provider having to go through these assessments and all these things that they have to do in order to ensure that they can extend you the credit. So those two concepts need to be balanced if one wants to challenge this. And it is better form undoubtedly better form to rather obtain the consent, and its policy with the platform we use internally as well as within the industry. So unfortunate circumstance, and I do think one could complain with the National Credit Regulator, but whether or not there'll be an award of damages or some compensation for the inconvenience, I'm very reluctant to say.
Right, but he doesn't really have a leg to stand on effectively.
No, unfortunately not really. But in future, I would say be proactive and say to the credit provider, listen, are you going to do a credit check? If so,
not with this credit union.
Not with them, yes.
Yeah, so you can actually, but then I don't think he was aware they were just going to do it anyway. So,
And most of the financial institutions actually check across all the major ones, of which there are 3 in the country. So there are 3 that they, I almost want to dare to say, go through as a default because they are the largest.
Okay, right. We've got one more email to go. So if you'd like to call through now, 0892 10 2010, 0892 10 2010. Right, this was an email which I'm having a bit of a problem reading it, and I'll do the best I can because half of it was missing. The left-hand side of the page didn't come through, so I'm sort of guessing at what the words were on the left-hand side. I think it says, my niece, after the death of our mother, came and occupied my mother's house, which we were living in. To avoid a conflict or a fight, I decided to move and stay at my sister's. There can't be 2 bulls in the same kraal. Unfortunately, our mother never made a will protecting her daughter, my sister, whose mother went to the masters and forged our signatures as an executor. We opened up a docket when she was found guilty and given 1 year imprisonment or 6,000 Rand fine and 3 years suspended sentence. My niece has now got an RDP house and she's renting it to other tenants. When going to the municipal office to find out does she rent, she never stated that, and it's now 6 years. The rates are 8,000 Rand. What must I do? I want to apply for an eviction order. So obviously, from what I can gather here, the niece is still staying in the mother's house. There was no will.
So the property would obviously have transferred to the heirs, and in case of intestate succession, under the presumption that the spouse had predeceased the mother, then it would go to the children. So the niece could only inherit lawfully if her mother predeceased the deceased. So it can't go down the family line to the children unless the parent of that child is also predeceased. So,
but if there's just one child, and then the niece, the child would get it surely.
Yeah, if let's say there are two children, two siblings, and one of them has a daughter, and the one who has the daughter dies before the deceased, then that child represents the deceased sibling. So if that hasn't happened, the niece has no lawful claim to the ownership of the property. But the
niece's mother went to the master, and forged the signatures as an executor.
Yes.
Okay, so then obviously the mother, the other sibling, is still alive at this point.
Yes, so I don't know. Obviously, one will have to look at all the facts here, but usually there's a concept that, if the crime involved something a little more serious, I mean, if you forge signatures to get yourself...
She was given a jail sentence or a suspended sentence.
But if you forge signatures to get yourself appointed as an executor, it's not quite the same as killing someone in order to inherit from them. So what I'm trying to say is the crime may have disqualified her depending on, what else it involved. But let's take it on face value and it only involved the forgery. Then she would still be entitled to inherit, which means there's no lawful ownership passing to the niece, which means the only thing that the listener will have to ensure is that the deceased estate transferred the property to the two siblings or the people that were entitled to inherit.
Because there was no will, yeah.
Yeah, but the conveyancing process must have happened, and once that has happened, they need to have physical ownership on title deed of the property in order to commence an eviction process.
Because what he says as well is the niece also, besides living in the mother's house or in the aunt's house now, the niece also has an RDP house of her own, which she's renting out. But the apparent, it's been 6 years now this whole thing's going on. The rates on the mother's house, by all accounts, are 8,000 Rand, which he's obviously, assume they're having to pay. She doesn't think she's paying it.
The rates is the responsibility of the homeowner.
Well, that's the point.
And if the property has been transferred to the heirs, then they should have proportionally made these payments. If it's unfortunate that the niece is now occupying the property, but
he wants to apply for an eviction order now.
He can evict her, but he'll probably not be able to claim the arrear rates from her. The council is quite amenable to arrangements, provided that you make them and you stick to them. So I would advise the listener to ensure, go to the deeds office, check who owns the property, ensure that it is the heirs in terms of the will, and if it is, then you all jointly can launch eviction proceedings to get the niece out of the house. Once she's out, then of course you can make your arrangements with council and all of that. But I suspect a mother may not necessarily evict her own daughter from the house, so get some legal advice, get some representation, and... Well,
they would need to get somebody to help them with the eviction anyway.
Of course, and it could be quite... With all these variables, it could be quite a time-consuming and traumatic process, just so that they can go into this with open eyes.
Would it have any impact on the fact that he actually moved out?
No, not really. It's
Not.
all about ownership, and all the owners need to act jointly. So unless you can buy the other out or get them to buy you out and it becomes someone else's problem, or you are the only owner. If you're the only owner and you have to evict someone, it's much easier because there's only one person to sign paperwork and all of that. Only one person who's entitled to say you can stay or you must leave. Now, if there's two, one says yes and the other one says no, or four, two says yes, and so on, it makes it a very complicated process, and it causes a lot of unnecessary family politics.
That's why, as we keep saying, please
Get a will.
make a will.
Even if your dependents are now in agreement with one another.
It might not be next week.
Yeah, unfortunately.
And as I said, we've got
Jokes aside.
Wills Week coming up. And then what I normally do is I normally have a list of all the participating attorneys across the country in the different provinces. So you said it was starting when? On the
14th of
4th
September.
But the
Yes.
thing is, don't wait until the 13th
No,
to do
no.
something, because they get booked up very quickly.
They do. They do.
So I haven't looked yet, but I'm assuming in the next week or so, if probably not even maybe now already, there will be a list of participating attorneys on the
Yes.
Law Society's website.
There should be the Cape Law Society in any way. They have opened up the they've already contacted us for the stationery to be collected over 2 weeks ago. So it's really once that happens, it becomes official and everyone is listed and so on.
Okay, so what I did last year was that people were saying, well, I live in the Eastern Cape or I live in the Free State, and I would send them the list of the participating attorneys in their province or in the nearest town to them, and they could then make an appointment. That's the other thing. You have to make an appointment.
Yes.
So please, if you're interested in getting, it's a basic will. We'll explain that to you now. But if you do not have a will, please, for my nerves and my sanity, please go and get a will made. It's a basic will. It can't be a fancy one with trusts and all sorts of fancy other things. It's got to just be but that's all you need initially is a basic will.
I always say, start with what fits, the shoe that fits, and graduate it into what you need in life as life happens. Don't overcomplicate it if it needs not be complicated, and let it grow and evolve with you. It's supposed to speak for you when you can't speak for yourself anymore. So there's no need for it to be an intensely complicated document. So a simple will can get one a far way, and it is meant. The Wills Week is particularly meant. I cannot stress this enough, for our communities, for those who would otherwise never have the opportunity to have it professionally done. As a firm, we are we're quite adamant about that it's all about making an impact where we can make the most. And we have a bit of a policy not to, not really, we focus on helping communities and not really for a discount.
Yes.
For
someone who could actually afford to go and have it done somewhere else. So for those who actually can't afford to, in the normal course of the day, be able to afford to consult with one of the top attorneys, because these are all these are big firms that are putting themselves out there for Wills Week.
Exactly.
Putting something back.
Yeah, and we've always been committed to the Wills Week and love taking part. So it's really that time of year where we really feel we want to make an impact and make a difference. And it's really important. Remember, and I don't want to sound like we are dictating policy here. I mean, I'm not the rule making body, but if I can just applaud to the listeners that if you do appeal to them, if you are going to make use of the opportunity in Wills Week and you can actually afford to get a basic will done, please remember that slot can never be filled again. When time is gone, time is gone. And we really do try and help, particularly the elderly, and those people who really wouldn't have had the opportunity else.
Right. So if you are wanting to go and go and have the opportunity of having your will done, drop me an email now to law@safm.co.za. Tell me which province you're in or what town you're in which province, and then as soon as those lists are made available, I will let you know exactly who is doing this. And you need to phone quite soon because those slots get filled up very quickly.
Yeah.
So if you drop me a mail now, I'll keep a little database of all of you that email me, And I will then send you out the list of participating attorneys as soon as possible.
And
and just make the appointment, so at least you have a chance. Yeah.
And if you're very eager to get it done as soon as possible, then just Google your closest law society in the various provinces and phone them in the morning. They'll be able to point you towards a similar list within a couple of minutes. So we'll obviously do our best to get the word out there, but also if you need it urgently, you can always contact your local law society.
Right, so now I'm going to tell you something, and my exciting news for the week, and then ask you a question about that. My son got engaged a week ago today, so which I'm very happy about. My husband and I are absolutely thrilled to bits. But I now need to explain to him, and I'm thinking of sending him to you, to tell him the benefits of an antenuptial contract as opposed to a married in community or property situation. Could you, for the listeners, explain that all again?
No problem. I'm also a firm believer that it's the start of a well-built union, a successful one, a transparent one, and one of the ways in which you can actually prove your love for your spouse to be, and as opposed to the conception of it being a preemptive move or an idea that maybe it's not going to work out. I think that's a very cynical way of looking at it. And many couples over the years that I have helped with the antenup, many of them have come back and said, you know what, actually it makes sense. We are open about what our expectations are going into this, what potential risks there could be if we didn't talk about this, and now we can move forward with open eyes. So if you're married in community of property, it essentially means that whatever you have now and in future, you'll share with your other half. And whatever you have means all your assets as well as your liabilities, all your debts as well as your assets. So anything you come in with, to a certain extent, some things may be excluded, and everything that happens during the marriage will be shared equally.
We had a very sad story a couple of weeks ago. I'm not sure if you remember that man who had bought a house, had paid off the house, and then got married after the fact. The wife had then run off with somebody else, had now fallen pregnant by the new boyfriend, was now divorcing the husband. But he, to be able to pay her share, had to sell his house that he came into the marriage with fully paid for. He had to sell the house and give her half.
Yeah.
And that's what happens in community of property.
Exactly. So everything that you've maybe even if you've waited a little bit to get married, and some of us don't get married as early anymore, then you've built up maybe a career and a couple of assets, and you've paid your bond and all of that, then that situation could also become your reality. And it's not just about that. Sometimes people have the best of intentions, and something just doesn't work out. Some business decision was really not well thought through, and it doesn't work out. And when that happens and you become sequestrated or liquidated, then your spouse is automatically also, which means, everything gets sold and your creditors get paid cents in the rand, and you are in that situation for the next at least 10 years. So there are really, not to mention whoever passes away first leaves the other one in a pickle. Everything is frozen because it's this joint estate between the two of them.
Could you explain that when you in a community of property and one spouse dies, what happens to the estate? It's frozen.
Everything gets frozen. So
how does the other spouse then survive?
Well, you'll make usually these days people have separate banking accounts that they run, so that if something like that were to happen, they've got at least access to some funds until the whole process is dealt with. Also, insurance policies are made out to the spouse, which pays out in a couple of days after someone passes away, usually, or a month, usually the longest waiting period. Then you've got your and then you've got the cash in hand, and you can at least go and survive the next couple of months and all the accounts that keep coming in. But it's really not a very practical situation. So even from a day-to-day perspective.
What is the situation now with marital powers? Does the wife still have to get the husband's permission to sign anything?
No, that's been abolished
completely.
in 1984 with the introduction of the accrual system. So you, from a day-to-day perspective, you also need to have permission of your spouse. Either way, regardless of
So
gender.
you do. So one of you. So you can't sort of go. One of you can't go and buy a house without the permission of the other one.
Exactly. Sometimes it still happens though.
So the marital power is still there, but it's now no longer just the wife who has to get the permission. The husband has to as well.
It's both ways. So it becomes a very laborious process to run this. I need a new checking account. I need an overdraft facility. Let's both get into this, in our busy schedules. Let's try and align those schedules to get to the bank at the same time. And so on. It becomes a very impractical situation. So for all those reasons, amongst others, we don't recommend that couples get married without an antenup, regardless of which one you choose. The community of property system just isn't very feasible or constructive these days.
It's not practical by all accounts.
Completely not. Then you've got the other two. You've got the marriage without the accrual system, which essentially means what is mine and what is yours is yours. So anything that you can prove ownership of, you walk out with. The problem is the longer people are together, the less people can prove who bought that couch suite and who bought that dining room table. So there is a bit of, we need to decide how we're going to handle this. Are we going to predetermine if something does go wrong, then this is how we split things up? Or are we going to say, let's try and run it so we can always prove ownership? Or, let's deal with that when we need to deal with that. So there are various options in running that. It can be very administrative or not. And then last but not least is the accrual system, which essentially still splits the two estates as the without accrual does, with the what is mine and what is yours yours system, but it incorporates a calculation to take place either on death or divorce. So you'll calculate what you've brought into the marriage, your asset value, and then at the end of the marriage, a further calculation will take place to see how much asset value you have at that point. So the end value minus the beginning value, and the person who has shown the most growth shares with the person who's shown the least, in simple terms. So there's a calculation that takes place, and there is a degree of sharing, but it's not necessarily 50-50. It's a little more, there's a little more to it than that. But overall, it was structured so that there's financial equality, particularly with younger couples where one party may have to stay at home and tend to the family for the first couple of years, or, there's a difference in income, earning capacity, and the one feels they want to share with the other. So it's not necessarily only geared to creating equality between men and women. It can go either way these days.
Well, we've got Joey on the line who wants to talk about married in community of property. Joey, good evening.
Hello. I just want to know, I have a cousin who is married in a community of property. When she has investments that's on her name, and according to my opinion, when her husband dies, he's quite elderly. But besides that, if the husband dies before her, do those investments also go into the estate? She says no, but I say yes. Who is wrong or who is right, please?
What type of insurance policy did you say it is?
It's investments. She's got investments on her name.
Okay. Well, essentially, they share everything. So just as much as he has to share whatever investments he has 50-50 with her, she has to share whatever she has 50-50 with him.
That's correct, yes.
Yes, so I agree with the person who said she has to share with him.
Yeah, I think it was you, Joey. You said
but
it.
What I want to know is if he dies, or when if he dies before her, the investments that are on her name, does that also go into the estate?
Yes.
Or not?
Yes.
Does it?
It gets, when someone dies and you're married in community of property, they actually do a tally of both your estates. And then they chop it in the middle.
But I want, as I say, I want to know, because they maintain that because the investments are on her name, it doesn't go into the estate. But according to my knowledge, it does go into the estate. So, in
Yeah.
other words, it's everything that gets frozen.
Yes. Everything that she owns and that he owns goes into this joint pool, and it may happen that when you calculate the grand total of hers plus his and you divide it by 2, that her amount of her investments that she already has, she keeps, and it squares out practically. So theoretically, it goes into the pool. If you follow what I'm saying.
They've also got 2 vehicles, which are also on her name. But that also gets valuated and goes into the
Exactly.
estate.
So it may not necessarily happen that you actually have to hand over your investments, practically speaking, but you have to account for it.
That's it.
Yes.
So you were quite right, Joey. You were quite right.
Good evening to you.
Thanks, Joey.
Okay.
Good night to you.
Bye.
See, this is, I think, where the confusion comes in. Well, we're married in community of property, but I've got this fixed deposit and it's in my name.
Doesn't matter.
Tough. It's part of the community of property. That's the point. Community of property.
Exactly.
All property is now communal.
I say to clients, if they struggle to draw the distinction, just think if some creditor is coming to claim against either of you, then they are going to take everything that there is to take. So you can't, if you say, okay, but if you pass away, now this is not part of the estate and that is not. Think of the estate as a creditor coming to collect. And if you see these the liquidation proceedings and sequestrations, they come and collect across the board, regardless of whose name it is in. It doesn't matter. If you're married in community of property, it overrides that principle.
Does that affect accrual when you're married with accrual at all?
No. Some people do have the misconception or don't understand the accrual correctly in that they think that there's some form of co-mingling.
Because it always sounds to me like it's an anti-nuptial contract with the community of property in the middle. Like a sandwich, with some ham in the middle kind of thing.
No, there's a complete division of estates, and the only thing that if you were to have any property together, let's say a house, then 50% goes into this pool and 50% would go into the other pool. And when you start doing that calculation of what you came in with and what you have now at the time of the calculation, then it will just affect the calculation, but it wouldn't necessarily mean that, but that is half mine.
What if a creditor came sort of knocking on your door?
The thing with the accrual is it cannot be claimed against the calculation until it happens. So, of course, if you happen to get divorced, someone passes away, simultaneously with some creditor wanting some money from you, then they can lay claim to that money that is yielded from the accrual claim, but not before the claim actually falls to you. You can't attach it, you can't use it for security or anything like that.
So it is quite a safer way.
It is safer, and I think in many instances it's a fair system, particularly if there isn't the same earning capacity between two spouses. For example, if one is a highly specialized medical practitioner and the other is in an administrative position, then regardless of who stays at home or who doesn't, there'll always be a difference. And then if there is a degree of I want to share and I want the system to think for me as opposed to making sure the scales are always even and people feel appreciated and valued regardless of what they bring to the table. It needs not be rands and cents. Then the accrual system is a very good alternative.
So I'm going to try not to be a bossy soon-to-be mother-in-law and just mention the part about, the wedding dresses and the cake and the venue and the music and the flowers and the anti-nuptial contract. It's all part of the planning for the wedding.
Yeah.
Right. Okay.
And don't leave it until the day before, please.
No, you know me, I will. It'll happen probably next week. It's like immediately. Right. My thanks once again this evening to Nicoline Skuman-Low. She's a director of Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town. And she's been my guest on tonight's edition of the Law Report program. And Nicoline will be back with us again for another law clinic on Monday, the 14th of September. Nicoline, once again, thank you very much for joining us.
Thank you for having me, as always. Thanks.